here would listen today to John McNaught. Thank you for coming here and start your...
Well, thank you very much, Heinz. It's a great pleasure, ladies and gentlemen, to be here to meet new friends and to talk about our system. And I think in some ways you will find that if you came to watch me in a court, you would say that our procedures were in some ways very informal, much less formal than what I've been hearing from colleagues here, especially the German colleague who described the formalities of the German system. I think I want to remind you as a starting point that I work and I'm familiar with a system which is an adversarial system, not an inquisitorial system. So the judge, the role of the judge in the English court is not to investigate the truth. The role of the judge, whether in a criminal case or a civil case, and of course it's civil cases that I'm going to be concentrating on this afternoon, the role of the judge is very much that of the umpire of a game. It's a game between two or more parties. The judge is there to see, like the umpire or the referee of a game, first of all, that the rules are kept to. But of course, with lawyers who understand the rules, that part of the judge's job is usually pretty straightforward. And to see that the trial just goes according to the rules. So it is not in the English court the judge's job to gather the evidence or to promote one side of the case against another. But having said that, I want to imagine life before a big milestone, which I'm going to tell you about, which we marked in 1999. Because before 1999, our system of civil cases was frankly pretty inefficient. There was no control over the speed at which a case was conducted. You could start your case before a court. Nobody would really push you to get a move on to the next stage. Cases could go on for months and years, all the way along the road, the lawyers building up their fees. And only in the most extreme cases would the court say, well, you've wasted too much time, you haven't got on with this case, we shall strike it out. But that was very rare. The cases were proceeding very slowly. There was no control over really which judge did which sort of case. So it meant that large resources were being spent by highly trained, very senior judges dealing with rather trivial cases and taking a long time over it. So building up delays in the system. And so in the 1990s, a commission of inquiry under Lord Woolf, who had been the Lord Chief Justice, produced the Woolf Report and led to a revolution. Ladies and gentlemen, it was no less really than a revolution in 1999, when in April of 1999 the Civil Procedure Review, the Civil Procedure Reforms came into force. And from being a judge who was a dumb umpire in dealing with the case, run by the parties and taking as long as they want about it, the court began to take, and takes increasingly, a very robust part in the management of a case, the preparation of the case, the getting of a case ready for trial. And it did so by following the rules set out in the 1999 Civil Procedure Rules, which are written in very simple language. And the idea of the simple language is that they should be accessible not only to lawyers but to ordinary people, and that they should have as a guiding principle what Lord Woolf called an overriding objective. So the first part of the rules say this: These rules are a new procedural code with the overriding objective of enabling the court to deal with cases justly. Dealing with a case justly includes, so far as is practicable, A, ensuring that the parties are on an equal footing, B, saving expense, dealing with the case in ways which are proportionate to the amount of money involved, to the importance of the case, to the complexity of the case, to the financial position of each party, and to ensure that the case is dealt with expeditiously, that means quickly and fairly, allotting to it an appropriate share of the court's resources, while taking into account the need to allocate resources to other cases. In other words, the court's budget is a fixed budget. It isn't unlimited, so you must use it in a way which is proportionate to the case which you're dealing with it. And the court must seek to give effect to the overriding objective when it exercises any power. Now that was really a revolution, and it changed fundamentally the way we do things. The essence of the revolution was this. As soon as a claim is lodged with the court decides how it shall then proceed. And it does it by assigning it, directing it, in one of three directions. There are three different tracks in which it can be guided. There is, first of all, the small claims track, which is appropriate for cases of up to £5,000. Actually, in April this year, on April the 11th this year, that limit was raised to £10,000. And that small claims track has its own procedure. For more serious cases involving now, since April the 11th, £25,000, those cases are assigned to what is called the fast track, and a different regime of procedure applies to the fast track cases. Over that limit of £25,000, cases are assigned to what is called the multi-track. Now, I must just pause there and explain for those of you who don't know the hierarchy of civil judges in England and Wales. At the bottom of the hierarchy is the district judge. There are about 450 district judges up and about the country. They're all judges who deal with nothing but civil cases. They are, in many ways, procedural judges. They have most of the responsibility for operating these rules since the Wolf report. But they also have their own trial jurisdiction, and I'll come back to that in a moment. Above them are circuit judges. There are 650 or so circuit judges currently. I was a circuit judge, I'm now a retired circuit judge, and they have a jurisdiction which is greater. And above that, the third level of trial judge is the High Court judge. There are about 110 of those High Court judges. They're all based in London, and they have unlimited jurisdiction in trial cases. Now, what is the broad rule of these allotment track? Well, a case which is in the small claims track is up to £10,000. The procedure in the small claims track is very informal. It's very speedy. The aim is that from lodging your case to getting a decision from a judge, it should be done within 6 weeks. The rules of evidence are not very strictly enforced. Lawyers can appear but don't have to appear. But if you appear with a lawyer, you will not, if you win, you will not get your lawyer's costs paid by the other side. So there's no encouragement to have lawyers. So the small claims case should be dealt with within 6 weeks. If you're successful, you recover your claim, and you can also recover the costs of starting the case in the small claims track. And I'll come back and explain those in a moment. If the case is allotted to the fast track, that's up to £25,000. That presupposes that the case will take no more than 1 day. And that means that it's limited to those cases not only of £25,000 or less, but those which can be done in a day. So if you have a case where you have a lot of witnesses giving oral evidence, or you have experts giving evidence on both sides, you might need to allow more time, and you can't do it in 1 day. Therefore, it will be allotted to the multi-track. But fast-track cases should be done within 1 day as a hearing time, and they should be completed within 6 months from starting your claim. Above that, the fast-track, the multi-track are all the other cases. And there is a degree of flexibility and discretion about the allocation to tracks, because as we all understand, it's not always the amount of money claimed which decides the importance or the complexity of the case. There may be a particularly difficult point which is going to affect many, many other cases, which would fit within the lower track, but which, because it's an important case which will be relied on as a precedent in future, will be allotted to the multi-track and to be dealt with by a high court. So there is a degree of overlap of these things. Who actually tries them? Well, in the case of the High Court judge at the top of the pyramid, he will probably not try a case which involves less than £1 million, unless it's one of those cases which involves a point of great importance, principle, which is going to affect a lot of other cases, or attract a lot of widespread public interest. But he will do only the cases at the very top of the pile. Specially qualified, specially experienced circuit judges, called designated circuit judges, will do the bulk of the multi-track cases and will do also some fast-track cases. And they will do multi-track cases, usually between £500,000 and £1 million. Circuit judges, like me, I was not a designated civil circuit judge, I was a designated family judge, but that's by the by, would have a jurisdiction to do multi-track cases up to about £500,000. And I would sometimes also do fast-track cases which were dealt with in a day, and sometimes, if we were particularly pressed at work, where we had a number of judges, I would sometimes do fast-track cases, small claims cases as well. That was a rather interesting experience because it was so informal, there were no lawyers, the judge had to help the parties on both sides impartially and to deal as informally as possible, and that was rather a challenge if you weren't used to it. My colleagues who did small claims cases all the time found them very difficult because they were dealing so often with rather simple people who didn't understand court procedure, who couldn't explain things quickly, who didn't understand the need to get on with things, and it was quite a difficult thing. And involving, of course, some quite complex areas of law, consumer law, people who have some fitted carpets that don't fit properly or a washing machine that doesn't work, and it involves quite complicated areas of that. Well, now that was one of the principal changes of the 1999 reforms, to allot cases to one particular track rather than another. But it didn't stop there, because the duty was upon the court then to see that those tracks, the procedures required by those tracks were followed. And that involved giving powers, which almost always are exercised by the district judge, to identify the issues likely to arise in the trial, in some cases to limit the issues, to order the disclosure, the exchange of evidence, including witness statements before the trial, to lay down a timetable by which things should be done, to fix a trial date, a tell the parties what the trial date is, to decide whether experts should be instructed by one party or another party, or whether a joint expert should be instructed, lay down a timetable for the delivery of the report and the scope of it, and to decide where the trial was going to take place. Now, all those powers were backed up by sanctions, punishments available to the district judge, who could say, unless you follow this timetable, your case may be struck out. And they were very tough. They have been very tough to make sure that people understand these rules and that they exercise in that way a very close control. It means that when I come to try a case, and there's an example a bit later on this afternoon when we'll have the trial this afternoon, all the case management is done by that stage. Everything is done. The steps have been taken, the case is ready for trial, and the case is then put before the judge, who will hear it and decide it on the day and come to a decision on the day. At every stage, this is also a new feature of the Wolf Report, at every stage the court is keen to encourage people to see if their differences can be resolved, to see if they can compromise, to see if they can get somebody to mediate, to go to alternative dispute resolution, with a view, frankly, to saving the considerable costs. The parties in a case like we're doing this afternoon, a road traffic case, have to follow rules which mean that they must exchange some information. Even before they start a case, they must exchange information to see what the issues are, to see whether it can be settled without going to court. And if they don't follow those pre-action steps, they will be penalised in costs. And the final feature of the Wolf reforms was to emphasise at all stages to the parties how much this exercise is costing them. So at every stage at which the district judge deals with a case procedurally, he will expect to have a certificate from each side saying how much has been spent so far on this case. And as a new procedure this year, there is a thing called a costs budget for big cases. Parties must file a costs budget to say not only how much they've spent so far, but how much the whole action to trial is going to cost. And that concentrates the minds on the enormous costs. One of my colleagues was telling me the other day that he deals with many, many small cases where the claim is dealt with and the judgment is £5,000 or £6,000. A simple road accident with perhaps a minor neck injury, some damage to the car, and the claim succeeds and the award is £5,000 or £6,000. But the costs claimed are often £10,000 or £12,000. And that's, of course, ridiculous. And so at all stages, the district judges try to say what the costs are going to be. Let me just say what the court costs are. Let me take, when I talk about this, I'm talking about the costs payable by the litigants to the court, not to their lawyers. If you bring a claim, you must say in your claim what you think it's worth. And let's say we're going to bring a claim in the court for £10,000. You must pay a fee to issue that claim, to lodge it at court. You must pay it up front, £245. When the district judge considers the case and decides which route to set it on, which track to set it on, you have to pay another fee of £220. When the case is nearly ready for trial, the papers are considered by the district judge again to see if it is ready for trial, and there's another fee payable at that stage of £110. And then when the case is heard for the trial, before the trial takes place, you must pay a final fee, which is called a hearing fee, and that's £545. So for your £10,000 claim, you must pay out up front £1,120. If your claim is £100,000, then the costs rise because the issue fee goes up to £885 and the hearing fee goes up to £1,090. So to issue that sort of claim and bring it to trial is going to cost you £2,305. And that's over and above what you're going to have to pay to your lawyers to advise you, to get the case ready, to present the case, to appear for you in court. Let me talk about appeals. The right of appeals in civil cases is extremely limited. I would be exaggerating if I said it's been abolished. It hasn't been abolished, it exists, but it is very difficult in practice to appeal in England in a civil case. The fast track, the small claims track, at the bottom, there is in practice no right of appeal. You have your simple, quick procedure, you have your hearing, which takes an hour or so, you get your decision, and that's it, you're stuck with it. If you don't like the decision, well, that's hard luck, you're stuck with it. If you have a trial by a circuit judge or a high court judge and you're disappointed, and you want to appeal, you must first ask the trial judge for permission to appeal. And he will have given you a decision, you don't like it, so you say, please, Your Honour, or my Lord, I want permission to appeal. And if it were me, I would always say, I refuse you permission. I've done my best, I've listened to the case, I think I got it right, I refuse you permission to appeal. And that means you would have to go to the higher court, you would have to go to the Court of Appeal and say, we want to appeal in this case, the judge has refused permission, so we want to ask you for permission. And they would give that permission very, very grudgingly. So out of the hundreds and thousands of cases of all levels that are tried in England and Wales in a year, only about 1,000 ever get to the Court of Appeal. And it's a very small number that are successful. Because although the rules say that an appeal is by way of rehearing, it doesn't mean that at all. If you go to an appeal, if you're allowed to appeal, the appeal judges don't hear the witnesses, they don't see the evidence, they just consider the court papers, they consider the legal arguments, and they may say the trial judge was wrong. For example, in the football case we had yesterday with the broken nose, the judge might have awarded, say £5,000. And the insurance company says, that's ridiculous, it's far too much, we'll appeal. And they go to the Court of Appeal, and the three judges all say in the Court of Appeal, well, we think this is too high, we would not ourselves have awarded £3,000. But this case was tried by a judge, the judge has a bracket of discretion within which he can make a decision. We aren't going to interfere with that discretion. This is at the top end of that discretion, but we're not going to substitute our discretion for him. Appeal dismissed. Of course, if the judge had awarded, because he was a supporter of the same football club, if he'd awarded £1 million for the broken nose, well, they'd have done something about it. But even if the Court of Appeal say, we think this decision was wrong, we would not have made this decision ourselves, but nevertheless the appeal is dismissed. And of course, you won't be surprised if I tell you that there's quite a hefty fee payable if you lodge an appeal, and if you lose the appeal, of course, you'll have to pay the costs. I want to say a little bit about robes. What I'm wearing this afternoon is the dress that a QC would wear, Queen's Counsel. It's the same dress, in essence, that was worn since the beginning of the 18th century. It was first worn for the funeral of Queen Anne, and it stayed as court dress ever since. And when I sit in court as a retired judge, as a deputy judge, this is what I wear, and on top you will see that I wear a black robe. QCs are sometimes, as you may know, called silks, because traditionally they wear a robe which is made of silk. That's much too expensive now. They look like silk, but they're not silk. So I wear a black robe and I wear a wig in court. The lawyers in court, if I'm sitting in open court, the lawyers will also wear their robes, barristers' gown and wigs. Oddly enough, in the Supreme Court, our new highest court, replacing the House of Lords, neither the judges wear robes, they just wear ordinary suits, and they do not require advocates in front of them to wear robes either. That's all part of being user-friendly and modern that they've abolished that. Now, you'll find our procedure illustrated, I hope, by the little case we're going to do this afternoon. I think you'll find the procedure relaxed. Litigants do not have to have lawyers. The court cannot force them to have lawyers. If I were a judge and I had a litigant in person at an early stage, I would certainly advise him that it might well be in his interest to have a lawyer, because there might be things he didn't understand and it would be helpful to have a lawyer, but I can't compel him to have a lawyer. The case we're going to do this afternoon actually involves a dispute between two companies, and as an exception to the rule, a company must appear by a lawyer. So we shall have lawyers this afternoon. Evidence in open court is given on oath, so witnesses must take an oath. We talk of abolishing the oath. I don't think people take much notice of the oath, but nevertheless it's part of our procedure. So this afternoon we will invite the witnesses to take an oath. If they don't have a religious belief, or they have a religious belief that doesn't allow them to take oaths, they are allowed to affirm, which is a solemn promise to tell the truth when they give evidence. Sometimes, in a civil case, the witnesses in the case are asked to leave court before they give evidence, so they don't hear the other witnesses give evidence, but that's not very common. And the procedure is that it is the claimant who brings the case. The claimant will make an opening statement to the judge, telling the judge what the case is about in a few minutes. He will call his witnesses to give oral evidence. They'll be sworn to tell the truth. They'll give their evidence. They'll be cross-examined by the other lawyer. The defence will call their witnesses. They too are liable to be cross-examined by the claimant's lawyer. And then there will be the final submissions. The defendant always goes first because the claimant has the last word. That's just a rule that we have, that the claimant starts and has the last word. Listening to lawyers making speeches is an extremely tiresome business, I think. I've always made my mind up before the final speeches, and I usually spend the time when they're making final speeches writing my judgment. They think I'm writing notes about what they're saying, but I'm really writing the judgment. And sometimes I can say, if I'm going to find in favour of the claimant, I can listen, as I will do politely, to the defendant making his final speech. And then I will say to the advocate for the claimant, I need not trouble you, Mr. So-and-so, which is a good clue that I'm going to find in his favour. He doesn't have to address me because he's going to win, so he doesn't have to address me. And conversely, I can sometimes say in a case where I'm going to find in favour of the defendant, I may say, well, let's change the procedure a bit. I'd like to hear the claimant first, so that I can hear the claimant, and I know I'm going to find against the claimant, and then I can say, well, I needn't trouble you, Mr. So-and-so, for the defendant, because he knows he's won. And it saves me listening to two speeches. I only have to listen to one. The judge almost always will give a decision straight away, and he will announce a decision in a judgment. Sometimes I will rise for a few minutes to, if I haven't been making my notes for my judgment in the final speeches, I may go back to my chambers and retire for half an hour or so to write down the outlines of the judgment, but I may do it straight away. There's no set formula for the judgment, except it is a convention that I will summarise the issues, I will summarise the evidence that I've heard, and I will say what facts I find proved and what facts I don't find proved, and therefore base the conclusion. But there's no specific formality to it, and it doesn't have to be in writing. The only thing that is recorded in writing is the decision of the court, which is in the form, in this case there was judgment for the claimant for the sum of X pounds plus interest, and that's all it is. I have to deal then with costs. I have to deal with the possibility of the interest shall be added to the sum I award. The rules about interest are a bit complicated. I don't understand them, the lawyers understand them, and I always say to them, well, you're entitled to interest, you work it out and tell me what the figure is. And so I leave it to them. And then I have to deal with the point of an appeal. Please, may I appeal? No, you can't appeal. And that's that. And I try and be as kind as I can about that, but I've never ever given permission to appeal. You would only give permission if there was a really serious dispute on the law, about the state of the law. Well, the cases that I deal with in the courts, the cases we're dealing with here, don't involve any law. They're everyday cases, and they don't involve any law. We all know what the law is, so there's no need. I listen to the witnesses and say who I believe, and that's all I have to do. The evidence is tape recorded in court, and my judgment is tape recorded. I don't dictate anything in court. If there is an appeal, the parties can go to the company that has the contract for doing the recording, and they can, at a huge expense, they can get a typed out transcript of the judgment or any part of proceedings that they want. The cost's enormous. So it's the duty of the lawyers in a civil case in England to keep a note of my judgment. They each make a note of it, and if they want to appeal, they will get together and they will compare their notes, and they will prepare an agreed note of what I've said. Because I don't have it. I may have an outline of it, but I'm making it up as I go along, and the expense of transcribing it is very high. The Court of Appeal would be quite happy to look at an agreed note to see what happened. There it is, ladies and gentlemen. That's an outline of our procedure. Let me just tell you about the little case we're going to do this afternoon.
Ausland case, Ausland Foods Limited against Cubic Transportation Systems Limited.
Thank you very much. Please sit down.